All right, so have you ever looked at a legal document and just thought, okay, I see the words, but what on earth does this actually mean? Well, if you have, you've already bumped into the whole challenge of statutory interpretation. And listen, for professionals like chartered accountants, this isn't some dusty old academic thing. It's a skill you absolutely have to have. So today, we're going to open up the toolkit that judges use to figure out what a law is really trying to say.
You know, this quote from Lord Denning, it just hits the nail on the head. Laws are written in English, right? It's not like it's some perfect mathematical code. There's always going to be some room for ambiguity. I mean, think about it. Lawmakers just can't predict every single thing that's going to happen in the future. So when the words on the page aren't super clear, well, it's up to the courts to figure out what Parliament was trying to do in the first place. And that's the exact puzzle we're going to solve today.
All right, first up, the ambiguity of law. So why is this even a thing? Why can't we just, read a law and be done with it? Well, as we're about to see, interpretation isn't just a nice to have, it's an absolute necessity.
So the reasons are actually pretty straightforward when you think about it. First off, words can just be vague. I mean, take a simple word like vehicle. What does that even cover? Is a scooter a vehicle? What about an electric skateboard? See what I mean? And second, the people who wrote these laws years ago, there's no way they could have imagined all the stuff we have today, like cryptocurrency or gene editing. So interpretation is basically the bridge. It lets us apply these older laws to brand new problems, making sure the outcomes are fair and consistent, and connects what was written way back when to what's happening in the real world right now.
Okay, before we jump into the rules themselves, we've got to make sure we're all speaking the same language. So let's quickly go over a few key terms that you're going to see over and over again. First up, statute. So what is a statute? Super simple. It's just the official written law. It's what the legislator, like Parliament, wanted to do. They write it down, it gets passed as a bill, and then it gets that final stamp of approval from the president. Boom! It's now an official act.
All right, next up we have interpretation. This is all about finding the true meaning right from the words that are used in the law. The focus here is super narrow and precise. What does the law actually say? We're just looking at the plain, grammatical meaning of the words on the page.
And then there's construction. Now, it's best to think of this as going one step further. If interpretation is about what the law says, construction is about what the law means. It's where you have to kind of read between the lines to figure out the legislature's overall goal, especially when just looking at the words isn't enough to get the job done.
Okay, now really focus in on this one, because that exam tip label is there for a very good reason. This is a classic. The easiest way to nail this down is to think of it like this. Interpretation is about the letter of the law, what it literally says, word for word. Construction is about the spirit of the law, what it was trying to accomplish. Now, in the real world, people often use these terms as if they're the same thing. But for your exams, oh yeah, you absolutely need to know the difference.
All right, so we've got our key terms down. Now it's time for the main event, the primary rules of interpretation. And I want you to think of these less as super strict, rigid laws and more like a practical toolkit, the very tools that judges and lawyers pull out to make sense of complicated laws.
So we're going to focus on three main rules. It helps to think of them in a specific order, kind of like a hierarchy. We'll kick things off with the most fundamental one, the literal rule, and then we'll see what happens when that rule just doesn't cut it.
So, rule number one, and really the most important one, is the rule of literal construction. This is always your starting point. You just read the words and give them their natural, ordinary, everyday meaning. Their dictionary definition. And if the language is crystal clear, that's it. Job done. The court doesn't need to dig any deeper.
Now, there's a classic Latin maxim that sums this up perfectly. Absolutis intentia expositore non indigit. I know, it sounds fancy, but all it means is something incredibly simple. Plain words need no explanation. And that right there is the heart and soul of the literal rule. But what if you do that? What if you apply the literal meaning and it leads to a result that is just completely absurd or totally bizarre? Well, that's where rule number 2 comes in, the rule of reasonable construction. You'll also hear this called the golden rule, and it's basically a safety valve. It gives the court permission to tweak the literal meaning just enough to avoid a ridiculous result and find an interpretation that actually makes sense.
Okay, let's tackle the next big challenge. What do you do when the problem isn't absurdity, but when two different parts of the very same law seem to be saying opposite things? How do you solve that?
Well, this brings us to our third rule, the rule of harmonious construction. The main idea here is pretty simple. The courts assume that the lawmakers didn't mess up and intentionally contradict themselves. So you have to read the entire law as one complete document.
The goal is to make every single provision work together, to make all the pieces of the puzzle fit, instead of letting them fight with each other.
So how do the courts actually do this? Well, it's usually a two-step process. Step 1, they'll try their absolute best to interpret the clashing parts in a way that allows both of them to have some effect, to let them live in harmony. But if that's just not possible, they move to step 2. And this is where a really important principle comes into play. The specific rule will always beat the general rule. So a provision that's written for a very specific situation will always override a broader, more general one.
And here's the good news. Lawmakers often don't just leave you guessing. They actually build signposts right into the law. These are powerful little phrases that tell you exactly which provision wins in a fight. The big ones you need to watch for are subject to and notwithstanding. Just think of them as traffic signals that tell you who has the right of way.
And okay, let's zoom in here, because this is another massive exam tip. The notwithstanding clause, you'll also hear it called a non obstante clause, is one of the most powerful phrases in all of law. Seriously, it's a total trump card. And as you can see, its power level can change. It can be used to override just one other section, or the entire law it's written in, or even a completely different law. But the ultimate version, the one that says, notwithstanding anything in any other law, that one overrides everything. Understanding this power ranking is non-negotiable.
Whew, we have covered a lot of ground. So let's bring it all home and wrap this up with the key takeaways, the things you absolutely need to walk away with.
So what's the bottom line? Here's what you need to remember. 1, we need interpretation because words aren't perfect. 2, your starting point is always the literal rule. Just read the plain meaning. 3, if that plain meaning leads to a crazy result, switch to the reasonable rule to find a meaning that makes sense. 4, if two parts of a law are fighting, use the harmonious rule to make them play nice. And finally, always be on the lookout for those power phrases like notwithstanding, because they tell you exactly who's in charge.
So picture this. You're reading a law, and a single phrase can mean two completely different things. You know, this happens way more often than you'd think. So the big question is, who gets the final say? How do judges figure out the real intention behind the words written on the page?
Well, the answer is it's definitely not guesswork. There's a really structured process, almost like a legal detective's toolkit, and it's filled with what we call aids to interpretation. These are the principles that guide a judge to a logical and, most importantly, a defensible conclusion.
All right, first up, decoding the law. You see, reading a legal text isn't quite like reading a novel. It has its own specific set of rules, and they're all designed to uncover what the legislature was really trying to do. And the very first rule is to start your investigation inside the document itself. These clues, the ones left by lawmakers right there in the text, are called internal aids. They are always the first place any legal detective is going to look. So let's open up that toolkit.
Okay, here's a peek at what's inside the internal toolkit. It's got everything from the long title and preamble to definitional sections, schedules, you name it. We're going to focus on a few of the most critical ones that you're definitely going to run into.
First, we have the long title. Now, this isn't just the name of the act. Think of it as a full sentence that gives you a bird's eye view of the law's main objective. But here's the crucial rule. The title can help you understand the law's scope, but it can never, ever override the clear, plain meaning of a specific section.
Now, very similar to the long title is the preamble. This is like the law's mission statement. It often explains the problem the law was created to fix. It's a really powerful tool for clearing up any confusion. A perfect example is the Hindu Marriage Act. Its preamble says it's an act for marriage among Hindus. A court actually used this in the case of Gallipoli Surya Raj versus Bandaru Pavani to clarify that, yep, a marriage under that act has to be between two Hindus.
Okay, now if you're a student, I need you to lean in for this one. Probably the single most critical internal aid you need to know is the definitions section. This is basically the statute's own private dictionary, telling you exactly what a word means in the context of this specific act. All right, major exam tip right here. You have to pay close attention to whether a definition uses the word means or the word includes. When a law says a term means something, that definition is restrictive and it is final, it's exhaustive. But if it says a term includes something, that's extensive. It's just giving you examples, and the term can also cover other things that fit its ordinary meaning. Seriously, getting this right is a huge deal. Next up is a really tricky spot for a lot of people: provisos, exceptions, and saving clauses. They all kind of look the same, but they do very different things. A proviso carves out a special case from the main rule.
An exception basically says the main rule just doesn't apply in this situation. And a saving clause, that acts like a shield, protecting existing rights from the new law. The key takeaway is they all tweak a rule, but each in its own very distinct way.
So what happens when the clues inside the document just aren't cutting it? Well, that's when we're allowed to look outside the act itself, using what are known as external aids.
And this is a really critical step, right? Because no law exists in a vacuum. To really understand its purpose, judges have to look at the wider context, the world the law was actually meant to operate in. And that's exactly where external aids come into play. Our external toolkit includes things like the law's historical setting, any previous laws on the subject, long-standing practices, and even other similar laws, what lawyers call statutes in pari materia, which just means on the same subject.
I mean, looking at the historical setting is just common sense, isn't it? If you want to know what a law is supposed to do, it really helps to understand the problem it was created to solve. What was going on in society that made Parliament say, okay, we need to pass this law?
Another really powerful external aid is something called usage. Think about it like this. If a law has been understood and applied in one particular way for decades, courts are going to be very, very hesitant to suddenly change that interpretation. That long-standing practice itself becomes evidence of the law's original intent.
So, we've looked inside the act and we've looked outside of it, but all of these tools, every single one, is governed by one golden rule, the one principle that ties this entire process together. And here it is. You must read the statute as a whole. You can't just pull out one section or one sentence or one word and interpret it in a vacuum. Every single part has to be read in harmony with every other part. Context is absolutely everything. The whole goal is to make the entire act work together like a coherent logical system.